If you're heading into the IRS appeals process, you're standing at the final and most important stopping point before tax court. What you say, and especially what you don't say, can either save your case or lock you into thousands of dollars in tax penalties and interest. The appeals officer isn't your auditor. They are a negotiator, a mediator, and a closer. And they already know the weaknesses in your file, mostly because most of them are ex-auditor. Before you speak a single word, you need to know the rules of this arena. Hi, I'm David W. Klasing, a dual licensed tax attorney and CPA. And for over 25 years, I've represented clients before the IRS Independent Office of Appeals and Tax Court. Appeals is the division designed to settle tax disputes without going to tax court. Handled correctly, appeals is your best chance to fix an audit. Handled incorrectly, you might as well hand the IRS a win. The IRS Appeals Office is very different from audit. They are independent from exam, and their mission is to resolve disputes based on the hazards of litigation, not whether the examiner was technically correct or not. This means appeals officers ask one question. If this went to tax court, what are the risks for both sides? Who would prevail? If you can show the IRS might lose on a technical issue, or a factual issue, or due to incomplete records from the auditor, you gain negotiation power. But if you walk in unprepared, appeals will rely heavily on the examiner's findings, and your last chances drop fast. Appeals officers have come to expect clear explanations, organized evidence, direct answers, and whatever you do, don't give them emotional arguments. The fastest way to lose credibility is to go in there rambling, speculating, and complaining. Instead, communicate like this. State the issue. Explain why the examiner was wrong or incomplete on that issue. Provide supporting documentation. Whatever you do, show the litigation risks for the IRS, why you would win if this went to trial. Appeals officers respect logic, not volume, and its associated flying saliva. Every statement should be calmly, logically, and persuasively made to move your case forward. Avoid these fatal mistakes. Admitting facts you can't prove. Credibility is like virginity, you can only lose it once. Guessing about transactions you don't remember. Saying, I didn't know the rule. Blaming your accountant for everything. Whatever you do, don't contradict your own tax returns. And the biggest mistake, believe it or not, is talking too much. Appeals is not a therapy session. Anything you say becomes part of the record if the case moves on to tax court and taken over by Chief Counsel's office. Silence is power, and precision wins. Your protest letter is the foundation of your case. We put in a ton of time into getting those right, because we often win on the protest letter on its own. In it, you must identify each issue you're protesting. You need to cite legal authority when possible that supports your position. And you need to argue why both the facts and the law are on your side, and if you went to tax court, why you'd win. You need to provide factual explanations, attach supporting documentation. You need to request an in-person or virtual conference. And you need to state your desired resolution. Weak protest letters kill cases before they even start. A strong one forces appeals to seriously consider your litigation position and to weigh the hazards of litigation in your favor. This is one of the most important parts of the entire appeals process, and it's where most self-represented taxpayers fail, and frankly, most non-attorneys can't write a persuasive petition. It's the unauthorized practice of law as well. Appeals officers review accuracy of the examiner's findings, supporting documentation, and legal arguments. They're looking for inconsistencies between records and testimony. They want to know whether the IRS followed proper procedure and whether the taxpayer appears credible. They also consider the likelihood of IRS success in court. A huge advantage if you can demonstrate weakness in the IRS's position. Appeals cares about litigation risk, not punishing taxpayers. Your job is to help them see that risk clearly. Dumping a ton of documents on appeals doesn't help. You need to present organized binders or index PDFs. You need to give them summaries that tie documentation back to specific audit issues. You need to give them reconciliations for income, expenses, and bank deposits. Timelines for events or transactions. The more work you do to make evidence quickly usable and accessible, the more weight your litigation arguments carry. And whatever you do, never send them original documents. Appeals retains whatever you provide. You normally have the right to request a phone conference, a video conference, or an in-person meeting. In-person or video conferences are often much more effective because they allow you to read the appeals officer's reactions and respond in real time. Body language communicates. But no matter the format, your attorney should speak more than you do. Appeals works when the auditor misapplied the law, the auditor missed facts or misunderstood them, records were ignored, the IRS faces litigation risk. That's when you really prevail. Appeals does not work when the taxpayer hides information, fraud indicators are present in the fact pattern, records are missing, and income was intentionally omitted. Here's the problem. Appeals can also refer a case to IRS criminal investigation. If fraud becomes evident, this is one more reason why you need the right representative to go deal with these things. Here's why you really should have an attorney for your appeal. Appeals officers respect trained legal arguments, and they're often going to associate in IRS Chief Counsel's office their lawyers to bolster any IRS arguments or positions. A taxpayer cannot provide attorney-client privilege and cannot build a litigation-ready case. A dual-licensed attorney CPA can reconstruct records, develop legal arguments, and negotiate effectively using the IRS own standards of litigation risk. Handled correctly, appeals can reduce or eliminate major tax liabilities. Handled poorly, it can cement them in place. If you're preparing for an IRS appeals conference, don't go into this blindly. This is your last and best chance to fix whatever went wrong during the audit before actually having to walk into tax court. Call the tax law offices of David W. Klasing at 800-681-1295 or visit KlasingAssociates.com to schedule a confidential reduced-rate initial consultation today. We'll prepare your tax court petition, protect your rights, and put your case in the strongest position possible. To date, we have never lost in the tax court litigation process.